Judgment in the appeal, Mandalia, the Secretary of State for the Home Department.
Lord Wilson will explain the decision of the court.
In 2008, Mr. Mandalia came from India to study in the UK. His visa was due to expire on 9 February 2012, but he wanted to pursue a further course of study in accountancy. So, on 7 February 2012, he applied for his visa to be extended. In April 2012, the UK Border Agency refused his application. In these proceedings, Mr. Mandalia, who has meanwhile remained in the UK, claims that the agency's refusal of his application was unlawful. His claim failed in the Court of Appeal, but it succeeds before this court. The agency's rules for determining an application, such as that of Mr. Mandalia, are set within what is called a points-based system. He was applying under Tier 4 of the system. The rules referable to him required him to show various things, including that he was likely to have the funds with which to maintain himself in the UK during any further course of study. Specifically, under the rules as they were in 2012, he had to show that he had had at least £5,400 on 28 consecutive days, ending no earlier than a month prior to his application. The form which he had to complete made it clear to Mr. Mandalia that he had to show that he had 5,400. But the requirement for him to show that he'd had it for 28 days was buried away in other documents which, in the form, applicants were advised to read online. Mr. Mandalia sought to show that he had £5,400 by enclosing with his application his most recent bank statement. Actually, it showed that he had had at least £11,000 for the entire period which it covered, but it covered only 22 days to 19 January 2012. It failed to cover the first 6 of the necessary 28 days. The statement was numbered 64, so it would have been obvious to the agency that earlier statements covering the previous 6 days existed. The agency refused Mr. Mandalia's application on the basis that he'd failed to show that he'd had 5,400 for the full 28 days. It never invited him to try to repair the deficiency before refusing his application. The issue in the case is whether the agency acted lawfully in refusing Mr. Mandalia's application without first inviting him to try to repair the deficiency. If invited, he could easily have repaired it. His bank statements numbered 62 and 63 covered the previous 6 days and showed a credit balance of at least £11,000 throughout. The solution to the case lies in the guidance which was given by the Home Office to the agency's caseworkers and which was operative in April 2012. It was called Process Instruction Evidential Flexibility. It was made available to the public and so represents policy which the law requires the agency to have applied in the absence of good reason to the contrary. The guidance told the caseworkers that they could request an applicant to provide further information so long as the request was not speculative, that, for example, they should ask for bank statements missing from a series, and that, if in doubt about whether evidence existed, they should request it. We hold that Mr. Mandalia's bank statements, 62, 63, and 64, formed a series from which 62 and 63 were missing, and indeed that the more general guidance also clearly required the caseworker to invite Mr. Mandalia to try to cover those first 6 days. The decision to refuse his application without having done so reflects an unlawful failure to apply policy and must be quashed so that the decision can be taken again.